I will start with a brief overview of the procedural background of this evaluation. On 12 May 2023, the Commission sent you a request for submission of the 5-year Declaration of Assets and Personal Interest, and on 25 May, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did not submit and complete the questionnaire to the Commission. The Commission sent you 2 rounds of questions on 16 June and 28 June, respectively. You were asked a total number of 17 questions, including 71 subparts, and 46 of the questions included a request for further documentation. According to Article 3, Paragraph 4 of the Evaluation Rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification. Members of the Commission will now start with asking you questions, and Victoria Handy will start with asking questions first. We will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Victoria, you have the floor.
Good afternoon. The questions that we have to do with non-compliance with the legal regime of declaring personal assets and interests. And I'm going to first ask you about the failure to submit declarations for the period of 2014 through 2016. During your employment as a court clerk and then as a judicial assistant, you were required to file declarations in accordance with Law 1264 concerning the declaration and control of incomes and assets of state dignitaries, judges, prosecutors, civil servants, and some persons in leading positions, and Law number 133/2016 on the declaration of assets and personal interests. According to information from the National Integrity Authority, you submitted annual declarations for 2012 and 2013, 2017, 2018, and 2020, but you did not submit annual declarations for 2014, 2015, 2016, or 2019. In response to written questions from the Commission about your non-submission of declarations for 2014, 15, and 16, you stated that you did not submit annual declarations for those years because you were on maternity leave and then child care leave. And between 15 June 2014 until 3 April 2017, you took child care leave on the basis of Article 125 of the Labor Code that was in effect at that time. Law 133 on declaration of assets and personal interests that was in effect in 2017 required persons who were the subject of declaration who had suspended work or service to submit a declaration within 30 days after reinstatement. You did not submit a declaration covering the 3 years that you were on leave upon your reinstatement as required by law. You did submit an annual declaration for 2017, signed on 30 March 2018. In response to further questions from the Commission, you stated that a few days after you were reinstated, you went to the Human Resources employee of the court and asked to be furnished with an electronic key to submit a declaration of assets and interests. You also submitted a written application to be issued an electronic key. From what you remember, when you repeatedly went to ask about the key, it was explained to you that the HR employee would collect several applications from employees who needed a key at that time to be submitted together to the authority responsible for issuing the keys, and when he received them, you would be notified. You further stated that after the 30-day deadline, when you applied again for the release of the key, it was recommended to you that you would submit the annual declaration for 2017. According to you, due to the flow of employees, court staff, clerks in relation to judges enjoyed less attention and exigency in filing the declarations of assets and interests. And you do not have a copy of the request for release of the electronic key, and the rest of your requests were made orally. So I'll begin by asking you some questions to establish the facts. Hopefully these can be answered with a yes or no response, and later I'll ask you some questions that will seek greater explanation. Please confirm that during your employment as a court clerk and then as a judicial assistant, you were required to file annual declarations in accordance with Law 124 and Law 133.
I confirm.
And please confirm that you submitted annual declarations for 2012, 2013, 2017, 2018, and 2020, but you did not submit annual declarations for 2014, 15, 16, or 2019.
I confirm.
Okay. And please confirm that in response to written questions from the Commission about the non-submission of declarations for 2014, 15, and 16, you stated that you did not submit annual declarations for those years because you were on maternity leave and then child care leave. Is that correct?
Yes, it's true.
And the dates that you were on child care leave were between 15 of June 2014 until 3 April of 2017, correct?
I confirm the period.
Okay. And please confirm that when you were reinstated of April 2017, you did not submit a declaration covering the 3-year period that you were on leave. Is that correct?
I confirm.
Okay. And can you confirm that law number 133, which was in force, the version in force in 2017, required persons who were the subject of declaration who had suspended work or service to submit a declaration within 30 days after reinstatement?
I confirm.
All right. And in response to further questions from the Commission, you stated that a few days after you were reinstated, you went to the Human Resources employee of the court and asked to be issued an electronic key to submit a declaration of assets and interests. Is that correct?
I confirm.
And do you recall the name of the Human Relations employee that you spoke with?
Yes, Olesya Rusu. That was the name of the HR person at that time. I don't know if she's still with Chisinau Court.
Okay. And please confirm that you also submitted a written application to be issued an electronic key.
Yes, I filed that request. So it was a free form. There was no register to keep track of that request. It was just a regular request that was supposed to go to the next authority.
And to whom did you submit the written application or the written request?
To the same person that I mentioned, Olesya Rusu, because I met her after when I got back to work.
Okay. And as I believe that you've already indicated to the Commission that you don't have a copy of the written request that you submitted.
No, I do not.
And your other requests for a key were made orally, correct?
Yes, orally.
Right. And please confirm that you also informed the Commission that from what you recall, when you repeatedly went to ask about the key, it was explained to you that the HR employee would collect several applications from employees to be submitted together to the authority responsible for issuing the keys. And when that employee received them, you would be notified. Is that correct?
I confirm.
Okay. And was that also a discussion with Ms. Russo, I believe you mentioned, that you spoke with earlier?
Yes, with her, because I did not interact with other people. So I interacted with Madame Russo.
Okay. So if you were having difficulty getting an electronic key, why didn't you just submit the declaration in paper?
Sorry, I did not understand your question. the request that I did not receive the electronic signature?
Right. If you were having difficulty getting the electronic key so that you could submit the declaration electronically, why didn't you just submit your declaration in paper rather than trying to submit it electronically?
Because at that time, the declaration was only electronic, and to be able to file it, you needed that electronic key. It was like a USB drive.
Okay, but law number 133 adopted in 2016, which was enforced in 2017, stated that all declarations could be, did not require submission of all electronic until 1 January 2018. Up until that time, they could be submitted electronically or in paper. Isn't that correct?
Honestly, from what I remember, it was my obligation to file it when I get the electronic key. I don't remember me having the opportunity to file it on paper.
Okay, and you informed the Commission that after the 30-day deadline, you applied again for the issuance of the key, and it was recommended to you to only file an annual declaration for 2017. Is that correct?
Yes, it is like that.
And who made that recommendation?
Same lady that I mentioned before. And since that timeline expired, she told me I had the possibility to file the declaration for 2017. Could you please speak a bit louder?
Okay, so you were aware that you had to submit a declaration for the 3-year period that you were on child care leave, which is why you asked HR to obtain a key in order to submit that declaration when you returned to work, correct?
Honestly, at that time, I knew that I had to file the declaration as being back at work. We did not discuss, the ones who are working in this field, they know what's our amount of work, and this obligation, I have to mention that this is my obligation, my duties, so.
Do you mean filing the declarations is your duties? I'm not sure I understood what you meant.
It is my obligation. I had to file these declarations, but I remember that I had to file the declaration when I was back at work. I'm not sure. I had to report for the period when my employment relationship was suspended.
So what did you think you were filing when you came back to work? What did you think the necessary declaration was?
I don't remember exactly, but probably in the first and second round of questions I answered. If I were to interpret correctly the legal provision, and that currently I studied them in much more detail, obviously I had the obligation to file a asset and personal interest declaration, even for the period that my employment was suspended. I just wanted to add that during that time when suspended, I was only receiving the allowance for a child, and I also mentioned their difference for the mother until the child gets the age of 3, and the child allowance for an underage child that I get even now. I did not have any other income during that period of time.
Okay. And it was suggested to you not to submit a declaration once the 30-day period was over, but to submit an annual declaration for 2017, correct?
I understand somehow, and the lady who was employed at that time, we have a high turnover of staff in courts, especially among clerks. I don't exclude that she somehow, taking into account that many clerks are coming and going, well, maybe I should have been more persuasive to actually get that key in order to fulfill my duty.
Okay. And when you returned from work, it was in April of 2017. And so if you had this discussion with her 30 days after that time expired, in about May of 2017, she tells you to just submit your declaration for 2017, but that's not going to be for another 10 months, correct?
Yes, meaning that the 30 days ran out since I got back to work, and that meant that I was supposed to file the declaration for the entire year of 2017 that I had to file in 2018.
Okay. And how did you think that the annual declaration for 2017 would cover personal interests for 2014, 15, and 16?
I was going to declare the child support, or child pension, as we said, or the income that I had. But having studied the appropriate legislation, I did not meet that amount of 15 average salaries per economy in an account, so that I could. That's how clear it was for me. I mean that my income was just subsistence level. I attached since 2015. Just a second. The subsistence level. In the rural area, because that's where I was living while I was on childcare leave, I was living in a village.
Okay, and focusing back on just filing a 2017 declaration, you seem to know that a declaration covering your leave was required because you tried to file it when you got back. Did you think it was reasonable that someone was telling you you didn't need to file a declaration covering that period of time?
I was not told that I should not file it, including for that period of time. But I was at certainty towards about us was very important. We were not so appreciated. We were informed about our duties, but it was very superficial. So I think that the biggest issue was that the turnover was very high. Usually a clerk works there for 2-3 months. Most of them are leaving afterwards.
Okay. And did you contact the National Integrity Authority to confirm the information, the advice you'd gotten about filing declarations?
No, I did not. I did not call them.
And you had mentioned that, and I think you've just touched again on the number of the flow of employees, and that clerks received less attention and I guess assistance in filing the declarations of assets and interests. Were clerks prevented from filing the declarations?
No, not prevented. I highlighted that we were informed that we have this duty, among others, but somehow we were not looked upon in the same way as judges, where there was more persuasion, like you have to do it, and also more strictly asking them to do that and to fill out the declaration of assets and personal interests.
And is there anything that you'd like to add or clarify with respect to this issue?
No, nothing to add.
Next, I'm going to ask you about the failure to declare your husband's bank accounts between 2012 and 2013. And according to information available to the Commission, during 2012 and 2013, your then husband maintained 10 bank accounts, 7 of which were opened between March and July of 2013. And according to Article 4, Paragraph 1, Lit D of Law Number 1264, in force until 1st of August 2016, the subject of the declaration had an obligation to declare in the annual declarations all financial assets, including bank accounts, including those of family members. You did not declare in 2012, your 2012 and 2013 annual declarations, the following bank accounts. For 2012, and I think we've given you a list, and I'm just going to refer to them, not by the actual account number, but just the number we've given them. Bank account number 1, which was opened on 23 October 2008. Bank account number 2, opened on 10 February 2009. And for 2013, you did not declare bank account number 1, again, which was opened on 23 October 2008. Bank account number 3, which was opened on 2 April 2013. Bank account number 4, which was opened on 28 March 2013. And then 4 bank accounts, bank account 5, 6, 7, and 8, all of which reportedly were opened on 28 May 2013. Bank account number 9, opened on 27 July 2023. And bank account number 10, opened on 28 May 2013. In response to written questions from the Commission about the non-declaration of your husband's bank accounts, you stated that your relations with your then husband were not good from the very beginning, and that ultimately you filed for divorce on 7 October 2015. You stated that you were unable to talk to him to provide you with information on the accounts and income held by him. And when relations between you were as good as possible, he was against providing you with information about his income, stating that he was declaring his income and that taxes were being withheld. Thus, you stated that you were unable to declare your husband's income during this period because you were not provided with this information. You informed the Commission that these accounts were brought to your attention now during the evaluation process for the first time. So I'll begin with some questions. Can you confirm that during 2012 and 2013, you were required to declare all bank accounts maintained by you and family members?
I confirm I had this obligation.
And are you able to confirm that during 2012, 2013, your then husband maintained 10 bank accounts, 7 of which were opened between March and July of 2013?
I found out about this during this hearing. I did not know about that before.
Okay. At the time, did you know whether your husband had any bank accounts during 2012 and 2013?
From what I remember, like we all employees, civil servants, had bank cards, meaning that the salary was received only on a bank account.
Right. And did you believe that was true also for your husband?
From what I remember, yes, he was saying he was getting his salary on a card.
Okay. And can you confirm that you did not declare in your 2012 and 2013 annual declarations the 10 bank accounts listed in the summary that we've provided you and that I just read?
I confirm I did not declare these accounts.
Okay. And in response to written questions from the Commission, you stated that your relations with your husband were not good from the beginning and that ultimately you filed for divorce. And you also stated that you were unable to talk to him to provide you with information on the accounts and income held by him. And when the relationship between you was as good as possible, he was against providing you with information about his income, stating that he was declaring his income and the taxes were being withheld. Is that correct?
I confirm.
Okay. And so you informed the Commission that you were unable to declare your husband's income during this period because you were not provided with this information. Is that correct?
Exactly. I did not declare because I was not given that information.
And you also informed the Commission that these bank accounts were brought to your attention now for the first time. Is that correct?
I confirm.
Okay. And I think we've furnished you copies of your 2012 and 2013 declarations. You did not declare your husband's income in your 2012 declaration, correct?
I confirm.
Okay. But it does appear that you declared his income in your 2013 declaration. Is that correct?
I mentioned it in the 2013 declaration, the information about his income. Most likely, we were in our relationship was in a better shape, and in a message or by phone call, he informed me what was his total income for 2013.
So you got that income information from him?
Yes, of course, only from him.
Okay. Is there anything you wish to add or clarify with respect to this issue?
I have nothing to add, only what I provided you in the answers to the first and second round questions.
I have no further questions.
Doamna Tipa, la rândul său vreau să vă salut.
Madam Tipa, I would like to greet you. The matters that we will address have already been addressed by the Commission earlier, so you are familiar with them. The first matter that I'd like us to touch upon is the failure to declare a 2013 donation. And the facts are the following. On the 17th of January 2013, your father executed donation contract number 366 of 17 January 2013, donating you 4,000 euros. Article 4, paragraph 1, letter A of the law number 1264, in force until the 1st of August 2016, provided that the subject of declaration had the obligation to declare in the annual declarations income obtained together with family members during the declaration period. You did not declare the 4,000 euros donation from your father in your 2013 annual declaration, signed on the 21st of February 2014. As an answer to the written questions from the Commission regarding that failure, you stated that you were informed by the person responsible for collecting declarations from the court where you worked that you didn't have to declare that donation because the money was a contribution to an investment, namely to the purchase of an apartment in Chisinau, and that you were to subsequently declare the ownership right when you would register the property. You also stated that the amount of 10,000 euros that you received from your former husband as a payment in your divorce settlement of the 7th of May 2019 included that amount of 4,000 euros. You also mentioned that that amount that you declared both in the declaration submitted to NIA for the year 2020, but also in the 5-year declaration and the declaration for the missing year 2019 included this payment. I would like to ask you a few questions to first establish the facts, and then we'll be able to have a thorough discussion about some specific circumstances regarding this matter. Please confirm that on the 17th of January 2013, your father executed donation contract number 366, donating you 4,000 euros to you, and that you did not declare the 4,000 euros donation from your father in your 2013 annual declaration signed and submitted on the 21st of February 2014. I confirm. Please confirm that, or otherwise, depending on whether you agree or not, that Article 4, Paragraph 1, letter A of the law number 1264 of 2002, in force until the 1st of August 2016, provided that the subject of the declaration had the obligation to declare in annual declarations income obtained together with family members during the declaration period. Do you agree that this provision required you to declare the 4,000 euros donation from your father? I confirm I had this obligation, I had the obligation to declare that donation. Please confirm that in your answers to the written questions from the Commission about this failure to declare the donation, you stated that you were informed by the person responsible for collecting declarations from the court where you worked that you didn't have to declare the donation because the money was the contribution to investments for the purchase of an apartment in Chisinau municipality, and that you would subsequently declare ownership when you would register that property. Is that correct? I confirm. Are we speaking about the same person that you mentioned earlier today, or is it a different person? Initially, I was hired in one of the districts of the court, and then I was transferred to Chisinau municipality. Who is that person? At that time, in Telenești district, that was Morgoci Ramona. I'm not sure whether she is still working at the court of Orhei with the office in Telenești. Did that advice seem reasonable to you? Well, I somehow had confidence, I had confidence in the employees of the court, given that they also were following some guidelines regarding how those declarations were to be filled out. And they were also responsible of giving us advice and supporting us with filling those declarations out. I apologize that I have to insist, but I would like to understand your position. You said that you trusted them, you had confidence in them. So when you took that piece of advice as a basis, did it seem bizarre, unusual to you that procurements, like if it wasn't mandatory to declare donations but only procurements made with those donations, then nobody would have otherwise had to ever declare a donation? I thought that I would further declare ownership regarding to that asset, and that respectively would then lead to showing the origin of the funds that I used to buy that property with at that time. Well, through the lens of the law enforcement, do you believe this is an acceptable formula, a good legal mechanism? I'm just trying to explain what my thought process was at the time, what I was thinking and believing at the time. Now, I certainly would like to support the idea that I should have declared that donation at that time. Another context-related question would be, you in fact did not buy an apartment in 2013 when you received the donation. No, I did not buy an apartment. Therefore, the 4,000 euros were not used in 2013. This money was given by my father to a construction company that was an investment contract. And according to the law of 2019, that is like a future asset, and therefore the obligation to register the purchase and procurement obligation emerged at that time. What was the fate of the 4,000 euros in 2013? That was a donation to the company, and as I declared in the rounds, that 10,000 euros included the 4,000 euros. This fact is also reflected in our settlement transaction. So that's why I said that the idea was that in the future I would declare this. But now I admit that I made a mistake and I should have declared it. I would like to additionally ask you, well, you've mentioned it earlier, you told us that the 10,000 euros that you received from your former husband included the 4,000 euros. Is that correct? So there is the reconciliation transaction right there in front of you, I believe. Yes. But the reconciliation transaction of the 7th of May 2019 shows that the 4,000 euros donation from your father was in your specific ownership. So that was yours. So how could it have been included in the 10,000 euros? I will reword it. I have the reconciliation transaction right here. Point 6 says that it is established that that is right of the person Anna Burdu, 4,000 euros as set out in the donation contract. Then point number 5, to Anna Burdu, that amount from Alexandru is given, the amount is 10,000 euros. Now the question is, from your husband, former husband, how much did you receive? 10,000 euros? Yes, I received 10,000 euros, but it included the 4,000 euros. That's exactly what I'm trying to get to the bottom of, to understand. He had the obligation, according to the reconciliation transaction, He had the obligation to give you the 10,000 euros. Now, in practical terms, how much money was actually given to you? Was it 10,000 or 6,000? The way I've explained also in the rounds of questions in writing, I explained that this money was transferred to the company by my father. And when we started doing this division of property, we amended that amount to show my share there, somehow showing that that is money belonging to my father. You know, Madam Tipa, I usually would like to ask. When I don't understand, I prefer to ask again. According to point 5 of the reconciliation transaction, your former husband was to transfer you an amount of 10,000 euros. Point 6 says that there is your right over 4,000 euros that is set out in the donation contract of 2013. Now, in practical terms, when this reconciliation transaction was being executed, was being performed, and now through the lens of the items that I just read out, how much money did your former husband give you? 10,000 euros in total, which did not include the 4,000 euros. They were separate. No, it included, it covered the 6,000, no, the 4,000. So the 4,000 are included in the 10,000. I will accept your answer. You mentioned that the 10,000 euros that you declared in the NIA declaration for the year 2020, but also in the 5-year declaration and the declaration for the missing year 2019, that we will further talk about later. You said that it included the 4,000 euros. You declared a bank account with 10,000 euros, correct? Correct. The 4,000 euros provided for in the donation contract, they were never declared by you as a donation, were they? No, they weren't. Now, given the complexity of the addressed matter, is there anything that you would like to add to further clarify this matter? No, there's nothing for me to add except for what I provided in writing during the rounds of questions and answers.
Yeah, I need a little clarification. If I understand the 4,000 euro donation from your father was paid to the construction company, correct?
Yes, that is correct.
It was not given to you or to your husband, the 4,000 euros.
It was donated for the purpose that I in the future would have a place to live in. So it was not there was no claim from my father over that apartment. It was an investment into an apartment that I was to live in with my ex-husband.
And the money was given to the construction company?
Exact.
Okay.
Right.
So how did that money end up in the 10,000 euros that your husband gave you as part of the settlement?
So there was the request for the division of assets, and I indicated this amount, and I asked for an increase in the share that would have otherwise belonged to me, because we were supposed to divide the assets that we had together, that we owned together with my husband at the time.
And my question was how the $4,000 that had been paid to the construction company could have been included in the $10,000 that your husband paid to you.
That was the deal that we arrived at the time. I and my former husband agreed on that like that. So he wouldn't have to pay these 4,000 euros to my father, but that they would be assumed to be included in that 10,000 amount, in that 10,000 euros amount.
But the $4,000 was your separate property, correct, as reflected in the agreement?
I was only to declare the apartment. That was the deal we had. It was the part of the relationship between the spouses. The former husband told my father when he gave me this money that if you don't trust us or me, you can go and donate that money to the company yourself. So that's how things unfolded at that moment in time. But that was happening back in 2013, early 2013.
And what happened to the $4,000 that had been donated to the 4,000 euros that had been donated to the construction company?
They became part of the entire amount that was supposed to be paid for the apartment. So in terms of the partition, we just partitioned the money that we invested because at the time the apartment was not yet habitable. So the apartment at that time did not exist as a finished asset at the time that we had to have this reconciliation process, like the partition of our assets. The apartment was not there yet.
And so did you ultimately get the apartment?
No. The partition referred to the amount. We agreed on that amount only to put an end to that situation. It all took us more than 3 years. And I was somehow happy to just put an end to it, and that would be it. And I think to this day, we would have, our file would have still been in court, I believe, to this day, if we didn't put an end to it at that time in that way.
And I'm not sure I exactly understand what's being translated to me as partition. Did you obtain any refund of the 4,000 euros that had been paid to you, that had been paid to the construction company?
I was supposed to get an increased share that should have belonged to me, and that was thanks to the investments given by my family at that moment in time. So there was this relationship between myself and my husband at the time that the relationship was not that good. When you speak about your relationship with the ex-husband, I mean, relationships with ex-husbands, my ex-spouses might always be difficult, but I'm still trying to put together some mathematical calculations. So the 4,000 euros, so that was part of the price. And point number 5 says 10,000. So it would turn out that you were supposed to get a total amount of 14,000. That's what we would think about. Now, as for the text and the way it's written in the transaction, I'm trying to think about that item, but it says, well, number 6, have a look at number 6. But then there's point 7.2, it says that my father has no claim over that amount, also because of the fact that the 10,000 euros includes the 4,000 euros, encompasses the 4,000 euros. Are you speaking about item number 7? Yes. So it says, shall be given to you for personal property, all the rights and obligations coming out of the donation contract between Mr. Tipa and Madam Tipa. And we say the name of the notary here. So what do you mean? At the end of the day, these 4,000 euros, were they separately provided for in the donation agreement? And point number 5 says 10,000 euros. That, at first sight, it sounds like they would have nothing to do with the 4,000 euros in the donation contract. That's where we have certainty. And maybe there's a way for you to explain this. How, out of the 10,000 euros provided for in item 5, how do you say that 4,000 are part of that are provided for in the in item number 6? The transaction between ourselves, we had agreed on it at that time, and we arrived at that. We've coordinated that. In total, I was attributed the amount of 10,000 euros that covers or includes the 4,000 euros as well.
Răspuns acceptat.
I will accept your answer, and if I may, I will move on to the next. The question also has to do with the failure to declaration, and is the failure to submit the annual declaration for 2019.
Faptele.
Now, as for the facts, the NIA has no record of a 2019 annual declaration filed by you. Now, with regards to that declaration, you mentioned that between the 17th of March 2020 and the 16th of May 2020, the country was under lockdown, and you stated that the lockdown commenced while you were on a sick leave. And you also stated that because the flash drive with your electronic signature was at your workplace, you were unable to submit the 2019 asset declaration for 2019, so you were not able to submit that by the 31st of March 2020. And you initially informed the Commission that after the 16th of May 2020, when you returned to your workplace, you tried a number of times to submit that declaration for 2019, but you did not manage to, and that you found out about the missing 2019 asset declaration when you were asked to submit the 5-year declaration as part of this evaluation. As an answer to the questions of the Commission about your failure to file the 2019 annual declaration, you explained that in March 2020 you were on a sick leave from March 23rd to March 27th, and due to the state of emergency established on the 17th of March 2020, you were unable to access your electronic signature, which you left at the office. You mentioned that after the 16th of May 2020, when you returned to work, you tried several times to submit that declaration, but you did not manage to, and that you found out about that failure only now. And then you declared that you tried a number of times to submit the declaration, and you repeated some actions of filing out the declaration. According to you, the program was quite slow, and it showed you that the signature was applied and the declaration was loaded and the page closed. And when you returned to fill out the declaration, the data was kept there. Having seen that the data was kept there, when you tried again to fill in the declaration, after a number of attempts, you did not insist on filing it repeatedly. My questions are, please confirm that with NIA that there is no 2019 annual declaration on file for you at NIA. I confirm. Also, please confirm that according to you, you only found out about the missing 2019 declaration. You found out about it recently when you were asked to submit the 5-year declaration as part of this evaluation. I confirm. Please confirm that with regards to the 2019 declaration, you stated that between the 17th of March 2020 and the 16th of May 2020, the country was at a lockdown. You also stated that this lockdown commenced while you were on a sick leave. Can you confirm this? I confirm. But still, you were on a sick leave between the 23rd of March and the 27th of March. Is that correct? Yes, I confirm. But this is happening after the lockdown was launched, was declared. Is that correct? Yes. So it turns out that your sick leave shouldn't have prevented you from filing the declaration, did it? If we take as a starting point that your sick leave started on the 23rd of March until the 27th of March, and considering that, so the sick leave started after the lockdown was announced. I would like to mention that as soon as the Commission declared a state of emergency, for a couple of days, everybody still worked in a normal work regime. Now, I can't tell precisely what is the date on which children and young children were not allowed to go to educational institutions anymore, because, and then a few days later, the employees of different institutions were also told to stay at home. So it was a little bit of a gradual exercise, not as soon, like immediately, the state of emergency was established. And I know there were a couple of days and until all civil servants were told to stay at home. This explanation that your thumb drive was at the workplace and that you were not able to file your 2019 annual declaration before the 21st of March 2020 because of that, is that still the case? Yes, I confirm that that was the case. You initially informed the Commission that after the 16th of May 2020, when you went back to the office, you tried a number of times, you had several attempts to submit the declaration, but you did not succeed. Is that correct? Do you still have this position? Yes. Please confirm that in your answers to the further questions from the Commission regarding your failure to submit the 2019 declaration, you stated that there were some issues with the program, the NEO website was not particularly working well. I confirm. While understanding that there were some technical issues, you still did not insist on filing it just to be certain that it is filled out and it's kept somewhere there, but you need still an electronic confirmation of the fact. I will explain. Every time I was trying to submit it, every time I was trying that, all the data that I introduced there was being kept. And I thought that there was some error there, so I thought that the program that was this integrated case management program, I thought it was something like that, because that program was also quite slow at the time. Things would take time to upload, so sometimes we would only upload 2 documents at a time, and there would also because that would be a system error, so we would end up uploading twice the same document. So that's why I thought it was an issue of that nature. So that's why I did not check. I only realized the declaration was not there now when I was asked about it, because if I were to become aware of it earlier as a declarant, and since I'm also in the register of declarants, then I could have actually also filed it belatedly. Now I cannot anymore file it because since 2021 I stopped being one of the people who are supposed to submit declarations. I'm not a declarant. Well, you partially answered the question that I was going to ask, but still I will ask it. So you need to receive a confirmation of the fact that you've submitted the declaration, and you didn't get one. Didn't it bother you that you did not receive that confirmation of the fact that you've uploaded successfully the declaration? For an impartial observer, this would lead to reasonable suspicion, doubt with regards to it not having been submitted. I explained in the written questions, and I will explain again, that I don't have any other explanations to provide than that. So the idea is that I would look there, it was saved there somehow, and I thought that the fact that I didn't get a confirmation was a system error at the time. That's what I believed. And you did not try to go to the website of NIA to see whether that process was successful or not. As I said, I checked now when I was prompted to, when I had to submit the 5-year declaration. I did not check earlier. I accept your answer. Is there anything that you would like to add with regards to this matter? Nothing in addition to what I've already said. And the last matter that I would like to address has to do with the failure to declare certain bank accounts for 2020. Now, the facts: in 2020, you had 4 bank accounts. In your 2020 annual declaration signed on the 24th of March 2021, you declared 1 bank account. I will not spell it out. You can see it for yourselves. It says account number 1, opened on the 23rd of April 2019. But you did not declare 3 other bank accounts. I mean, account number 2, number 3, number 4. The first one was opened on the 4th of December 2015, the second, and then the other one on the 20th November 2017, and the last non-declared one opened on the 23rd of April 2019. You can see them for yourselves. If there's anything you would like to check, you can have a look at that. No, I am aware of this information. I don't need to check. According to Article 4, Paragraph 1, letter D, the subject of declaration has the obligation to declare the financial assets owned by the subject of the declaration and family members, his or spouse, including as beneficial owners, if the total value of all of them exceeds the value of 15 average salaries in the economy. According to the government decision number 923 of 2020, the average salary per economy for 2021 was 8,716 lei. In 2021, the value of 15 average salaries in the economy was 130,740 lei. As an answer to the written questions from the Commission with regards to why you did not declare the 3 bank accounts, you stated that bank account number 2 was a salary account, that you declared your salary in each of your declarations. On that account, you've also received your scholarship from the NIJ, which you've also declared. You stated that bank account number 3 was the account to which your scholarship was transferred when you were during your master's education at the Technical University of Moldova. As for the bank account number 4, you stated that it was the account to which your annual interest would go to on the basis of the amount of 10,100 euros. Well, you did not declare the account in your upon living office declarations made in 2021. You indicated interest income of 92 euros. And that amount was withdrawn from the bank, and the account was closed on the 13th of May 2021. As regards the non-declaration of those bank accounts, you mentioned that according to the law number 133 of 2016, the obligation to declare arises when the value of the funds on the account cumulatively exceeds the amount of 15 average salaries in the economy. Well, these were the facts so far, and I confirm them. I will now ask you certain questions. Please confirm that in 2020 you had 4 bank accounts and that in your 2020 annual declaration for 2020, that's right. So I know the 24th of March 2021 you declared only 1 bank account, listed as bank account number 1, open on the 23rd of April 2019. And the written, as set out in the written summary we provided to you today, that's a deposit account. Please confirm that you did not declare the 3 other bank accounts earlier mentioned as bank accounts number 2, 3, and 4. I would like to specify that the value of amounts on these accounts, those amounts were declared in the declarations, in the annual declarations, but I did not declare the account per se. That was declared under income, so the salary, the interest, I've indicated under the column for interest. So there is a section, separate section, including that student stipend, the scholarship from the institute. So just to understand, when you say that it did not exceed the 15 average salaries, did you take into account number 1 as well? Because the law says no, we perhaps misunderstood things back then. We were filling out the declarations. Once I indicated the value, I did not indicate the account. I should have also indicated the account. So I made a mistake as far as I understood, but I had the obligation to declare the value, the amount on the account and the account itself.
We established that with the facts, but I still feel obliged to ascertain the situation, additionally to leave no room for interpretation. In response to the written questions from the Commission about why you did not declare the other 3 bank accounts, you stated that bank account number 2 was a salary account, and that you declared your salary every time in your declaration. Then you also had the account with the scholarship from the institute. Number 3 was the account where you received your scholarship during your master's studies. And as for bank account number 4, you stated that it's where the interest was covered. Well, why did not you declare your account in your living office declaration? You indicated an interest of 92 euros under that unit, amount that was withdrawn on May 13th, 2021, as mentioned. Is this a correct and accurate summary of the reasons for not declaring the bank account? Yes, I confirm. This is what I mentioned during the question rounds. Going back to the question I asked, when you make such statements like I did not have to declare because they were under 15 average salaries, I wanted to ask you, well, I wanted to go back to that topic. You informed us previously and you state now with respect to the non-declaration of those accounts. According to Law 133, the obligation to declare arises when the value of funds on the account exceeds the amount of 15 average salaries per economy, correct? I would like to add here that account number 1, the salary account, I reported the income, I did not report the account. But looking at the law, according in 2016, I had to declare both income and the number of the account. Because, well, I will try to make a general and simple question. Your argument during our communication and during the hearing, you were saying that accounts number 1 to 4 did not have to be declared because the amount there was not exceeding 15 salaries, and that's why you cumulatively on each separate account. For instance, the scholarship from the technical university was 840 lei per month. That was not exceeding 15 average salaries. This is how I understood. Also, I would like to read the legal provision. I mean, Article 4, Paragraph 1, saying that the subject declaration had to declare in annual declarations all financial assets, meaning bank accounts, if the cumulative value exceeds 15 average salary, which means that if the cumulative value exceeds that limit, you have to declare all of them, not only the accounts where the amount exceeded 15 salaries. I understood, and I explained you how I explained. 15 average salaries cumulated on one account, not all accounts together. I am explaining what I was thinking at that time. Well, your approach was that if each individual account does not exceed 15 salaries, it does not have to be declared. But based on the discussion that we're having now, and in terms of relevant provisions that I had to declare them. I understood that. I understood. Do you think it was an omission on your side? It was because I declared the amounts everywhere. I just did not declare the number of accounts. I had a different perception. Now I have more clarity about it. Anything additional here? I have nothing to add. Thank you very much for your answers.
I'm looking around whether any of the other colleagues has any questions. If that is not the case, then I would like you to give you the opportunity now to make a brief closing statement to the Commission. So please go ahead.
First of all, I would like to thank my family members that were by my side during all this time, and together with me, they were also subject to verification, so I have to admit that was a difficult period of time, but not impossible. Also, I would like to say that this exercise is a really welcome one, in my opinion, and for my future positions, as well as for my personal life, including keeping track of your financial aspects and filling out the declaration of assets and personal interests. I would also like to thank the Secretariat and the Pre-Vetting Commission for understanding and responsiveness, and I wish you a lot of health and peace to you and to everyone who will watch this hearing. Thank you for your attention.
Thank you very much. With this, we come to the end of the hearing. I thank you again for answering all the questions from the Commission, both in writing and also today at the hearing. The Commission will now withdraw for deliberations, and as much as possible, the Commission will strive at delivering a decision within a month after the date of this hearing. I hereby declare this hearing closed, and again, thank you for being here with us this afternoon. Thank you.